we're going to hear in a moment from Tena Pate. And Tena Pate, I've known her for a number of years now, probably over a decade. And I've been trying to get her for 3 years to come and speak. And she got the opportunity to come this year, so I'm very excited about that. It used to be called the Florida Parole Commission, but the name was changed a few years back to be the Florida Offender Review Commission. And this group, she was appointed 12 years ago by Governor Jeb Bush and the cabinet. So she has been there for a very long time. In fact, she's the longest serving female chair in almost 75-year history of the commission. She is term limited, so she is now having to leave, and she just announced that her last day is going to be March 31st, 2016. She served in 4 different governor's administrations: Governor Martinez, Childs, Buddy McKay, and Jeb Bush. And just earlier this year, she was made a distinguished alumnus of the FSU College of Criminology and Criminal Justice. So I asked her to come and talk to us a little bit about the commission and what they do, because I don't think that very many of us really understand exactly what all that they do. So let's please give a welcome to Tena Pate. Thank you so much.
Good afternoon. Are y'all having fun yet? Yeah. And I agree, it is very cold in this room. We will do our best to keep this lively. If y'all, I'm going to do like a minister would do. If y'all just want to move to the center of the room so I don't have to do this. But seriously, it is a privilege to be with y'all today. And I want to talk to you what I call the state's best kept secret. I do believe Representative Pilon would disagree with me, because in my chat with him earlier today, he told me that Sarasota was the state's best kept secret. But I think the Florida Commission on Offender Review, there's little known about the commission. We absolutely know about the word parole and parole commission and parole being abolished, but we don't know a whole lot about what the commission does. Part of that is because we just very silently do our work. I believe the work of the commission is instrumental in Florida enjoying the low crime rates that we do. It is because of our informed decisions. It is because of the evidence-based practices that we utilize, that we do carefully select those offenders to be re-entered into society, as well as uphold justice. And again, we do render mercy when it is appropriate. I want to talk to you about the roles and responsibilities of the commission, but before I do, we need to go on a brief historical journey of days gone by. If you were to pick up a copy of our annual report from 1941, and we even repeated it in last year's annual report, you would read this. In the early 1800s, state prisoners were leased to Florida companies to work as slave laborers. This era of inhumane and bitter treatment of prisoners ended after the notorious Tabor case. Martin Tabor was a young prisoner convicted of stealing a ride on a freight train. He died as a result of the brutal treatment administered by a lumber company boss to whom he was leased. An incensed public demanded the discontinuance of leasing prisoners, but prison overcrowding, the high cost of housing, and pressures for better treatment of prisoners set the stage for opportunists to peddle their influence in the pardoning of prisoners. The Pardon Board, which was created by the 1885 Florida Constitution, was composed of the governor and cabinet. Over time, and due to limitations of the pardon system, the Florida Parole and Probation Commission was created in 1941. Historical documents reveal the commission was created to provide greater protection of the people of the state through a more efficient administration of penal treatment, and at the same time ensure against injustice to any particular individual. It was created to relieve the burden of pardons of the staggering load under which it has been operating. It was created to limit the respective fields of operation for the Board of Pardons and the Parole Commission, so that each could function independently, efficiently, without any way interfering with or impairing the functioning of the other. Today, The commission, we call it the Commission on Offender Review, is an independent, autonomous decision-making body. We're quasi-judicial. Our headquarters are located in Tallahassee. We have 5 regional offices with 12 locations, and with the exception of 2 of our offices, we are co-located with the Department of Corrections. We are 132 FTE strong, and I say it that way for a reason. I believe it's very important the way you word a thing or word a matter, and our employees are strong. They are capable. We have an incredible team at the Commission, and that's the way I feel about them. They are an exceptional team. From 1941 to 1975, the Commission acted as the release authority for sentenced inmates. We provided recommendations to the Clemency Board, which we still do today, prepared sentencing recommendations to the courts for probation cases. We no longer do this. We made releasing decisions for parole. This is still current. And we supervised all inmates placed on parole and probation. And as you know from the testimony or the presentations that you've heard today, this too is no longer the case. In 1975, the Commission saw its first big adjustment, and that was when the supervision of offenders was transferred to the Department of Corrections. The next big change for the Commission occurred in 1983, and we all know this is when sentencing guidelines took effect and parole was simply or essentially abolished for the state, with the exception of certain cases up until 1995. Now today, if the Supreme Court overturns a death row case, more than likely that case or crime was committed during the time that parole laws were in place, and so that case would be subject to the Parole Commission's jurisdiction. Also, let's say a law enforcement agency gets involved and solves a cold case, a cold crime. Most times those cases are also under the jurisdiction of the Commission. And in another instance where these laws would take effect, let's say an adult today who was victimized as a child, sexual abuse maybe by a parent or a relative or some stranger, it really doesn't matter, but she decides as an adult she now wants to hold that offender accountable. Those cases, when they were committed, many, many years ago, would come under the current system. So the parole system is still in effect. I can tell you we paroled an individual last week. We have hearings tomorrow. I'll be scurrying back to Tallahassee this evening to complete my final review for my cases tomorrow. And unless I hear something that just totally is outside of what I anticipate, I have 4 parole votes for tomorrow. I have many other votes where I'm not going to be making any change. We may extend some dates because of disciplinary reports received, et cetera. So on any given week, we either extend dates, we deny release, we reduce a date, we can make no change, we can make program referrals. One of the things that I love that we heard today was the warden talking about our Hardy Life Path program. We heard a presentation from Hardy officials back, it was a couple of months ago, we were out on the road holding a hearing, and Hardy came and told us about what they were doing. So it's given us another opportunity to refer inmates to these programs to help them prepare themselves for release. I can tell you generally what happens once we determine that an inmate has turned that proverbial corner in changing the mindset or the criminal thinking patterns. We do start referring them to different institutions. Primarily the institutions we utilize would be Wakala Correctional Institution. They have incredible programming there. Sumter Lifers program, they have excellent program there, and that's really like the starting point for us because they deal with criminal thinking patterns. And then we will use Hardy or Charlotte Life Path program, and then we end up, for the most part, at Everglades Correctional Institution. They have a phenomenal program that really puts the finishing touches on the offenders. We have looked at our success rates, 96% success rate for parolees. That's huge, that's incredible. That is because of all the time we spend with them before we will actually cast that parole vote. Again, it's referral after referral. Sometimes they're delayed a while before they get out, but we're gonna make sure, because it's our names that go on the paperwork, we're gonna make sure that we're comfortable that they will no longer pose a threat to society. In fact, Florida law says we cannot release someone just because they have good behavior. We cannot release someone just because they are participating in programs. We have to know for certain that they will not be a public charge, that they will have a residence, that they will have places of employment, etc. So we're looking at all of these factors. And even sometimes it's so sad to say, because some of these cases occurred many, many years ago, and you can see that offenders are trying very hard to change their lives. But even sometimes a release may be delayed just because the case is so horrendous. And we're trying to balance, just like you heard earlier, you never want to do away with the professional judgment or discretion. You want to look at all the risk assessment tools always. I use a combination of 3 or 4 when I look at a case. And that way I know when I do say parole, I'm pretty comfortable that I've got it just right. But there are times when society has an expectation that these individuals are going to serve more of their sentence than less. So we're trying to find the right balance all the time. So that is what we do on the parole part. And this is a small portion, although it ties up the majority of the commissioner's time. And we have 3 commissioners statewide jurisdiction. And we are constantly reviewing cases. This is one of the reasons I wanted to change our name, because we no longer just do parole. We do parole, conditional medical release, conditional release, addiction recovery, and we also serve as the investigative and administrative arm for the Executive Board of Clemency. The other discretionary type program that we have is the conditional medical release program. Florida law allows the Department of Corrections to refer these cases to us when an inmate is permanently incapacitated or terminally ill. For the longest time, the commission had a policy in place where we would look at the case if the life expectancy was 6 months or less. In the last year, year and a half, I changed the policy to say we would look at cases where the life expectancy was 12 months or less. We've obviously seen an increase in referrals of the cases. I want to give you a little bit of the statistics on the conditional medical release cases. If I can find my notes, I'm just all over the page on my notes. Over a 7-year period, the commission has considered 191 inmates for conditional medical release, and almost half of those were released, while 79 or 41.4% were denied. Those that were released survived an average of 5 to 6 months after their release. Those that were released primarily came from, and actually it's more than 1/3 of all the releasees, came from Broward, Hillsborough, Miami-Dade, and Pinellas counties. 1/3 were serving time for drug offenses, followed by property crimes and burglary. Only 1 sex offender has been granted conditional medical release in the 7 years that we looked at. 4 of the 95 cases were serving life sentences. The remaining 91 cases had an average of slightly more than 5 years left on their sentence. Most of the inmates that we released were diagnosed with some form of cancer. Back on the parole cases, you know, we were talking about the different things that we look at, and all day long we've heard about risk assessment tools. In 1978, the Florida legislature created or enacted for us what we call the objective parole guidelines. And these guidelines help us to determine those that are ready for release or assessing the risk factors. I can tell you that the law also requires that we conduct a periodic review of these guidelines to determine if they are current with the research. The last time we updated these was last year, 2014, and we did this with the assistance of Dr. Blomberg, the Dean of FSU School of Criminology and Criminal Justice, Dr. Bill Bells, who's formerly an employee with the Department of Corrections, and then Dr. Pesta with FSU as well. How many of you know that FSU has the top-rated School of Criminology in the country? Okay, absolutely. So we were incredibly privileged to have them come to the table. We have a unique relationship with FSU. They're very supportive of the work we do. They are very much interested in the criminal justice policies across our state, as well as reentry, and they came to the table at no cost to the commission. So I'm very thankful to FSU for the assistance that they provide. But some of the risk factors that we look at when we are setting a date, would be the prior criminal history. We would also look at the types of crimes. We would look at how many times an inmate has been incarcerated and how long did they serve while they were incarcerated. We would look at whether or not they had ever been on community supervision, and if they violated, what were the behaviors when they did violate. Was there a history of escape? Did the crime involve a burglary, a breaking and entering, a robbery? These are all precursor crimes to more serious criminal behaviors. So we look at all of that. We also have the ability to look at mitigation. We look at the age of the offender at the time the crime was committed, whether or not they were under the influence of an older adult. Many of these cases that we have, they were juveniles at the time that they committed their crimes, and they are involved in the parole process today. We look at whether or not there have been any mental health issues or the substance abuse issues. So we look at all kinds of factors in determining what the date is, and then based on what the crimes are, we will see the case as required by law every 2 or even up to 7 years. Again, that depends on the crime. So I wanted to give you an update on those risk assessment tools that we use. Those are the 2 discretionary type release programs that we have. Our conditional release and addiction recovery are mandatory releases. The conditional release population are those offenders that the legislature has determined are the ones that pose the greatest risk to society, and they must be released at 85%, whether they have prepared themselves or not. I'm so thankful to tell you the department is busy about trying to get individuals into programming to help them successfully re-enter society. And the commission, by law, has to look at these cases 180 days before they are released and start imposing the conditions of their supervision. And again, we're looking at the case, we're looking at the crimes committed, we're looking at the behaviors involved in the crimes, and we're looking at the entire history and determining what those needs are that you heard about earlier. You have to determine what the right programming is. Our hope is that when they're out on supervision, they're going to be successful, and that the conditions that we impose are going to be a part of their success story. We find that that's not always the truth because there's limited time on supervision, and sometimes they struggle with finding employment to help pay the cost, or it's difficult for them to attend the programming, etc. So what we did, and this is one of our smart justice reforms, I partnered with the Department of Corrections, and we're currently at the Gadsden Reentry Center in Quincy. We're getting in earlier. Let's say our goal is to get in at 18 months, and I would love to be in at 24 months, but we're getting in at 18 months now, and we're starting to review those cases and impose the conditions at that time, giving the offender an idea of this is what it's going to look like for you out on supervision. If you can address any of these programming needs while you're there now, let's go ahead and do it now. And it may be that instead of the commissioners imposing mandatory programming, maybe it will be at the discretion of the officer based on the programs completed while they were behind bars. So it's our hope that getting in earlier on this project, that it will spread statewide and that we will see greater success when they are released. And again, these are the most dangerous offenders to our state. The addiction recovery population came about in 2001. This is for the low-level offenders, the substance abuse cases, and they are on supervision a very short time after they complete their sentence, but they too serve 85%. And we want everyone to succeed. Now, in all of these supervision areas, the other thing that we are very much involved is the revocation process. So as I've already said, the Department of Corrections actually does the supervision, and then they report to us or the court, depending if it's probation or parole. The courts handle probation, the commission handles parole and conditional release, addiction recovery, and that gets blurred. Every time you read an article, the reporter may say somebody was on parole and really they were on probation, or maybe they were on conditional release. That doesn't matter or make any difference really to the general public, but to us in the department, it absolutely makes all the difference in the world, and we're always saying, okay, was this our case? Find out, was this our case? So in the revocation process, the department will notify us of any violations of supervision. and we can issue a warrant and have the individual arrested, hold them accountable. We have options of leaving the individual in the community. We can impose, not only do they get to return to the community, but they maybe have a period of 3 or 6 months community control, or maybe we see that there's another programming need. We can also just say, we're going to give a letter of reprimand, and that's all. We're going to let him slide on this one because we don't believe that this warrants a return to prison, or we believe it was just a hiccup in the process. He's going to be okay after this. If we return to prison, we can revoke their supervision. We can grant or deny street time, and that means a lot to the offenders. Sometimes if they've been out a few years, and then their street time is denied, that's a huge setback. So that is something that we're trying to work on at the commission. It's something that we have been evolving in our thought process. I can tell you, when I first joined the commission in 2003, we always denied street time. Always. It wasn't even something that we contemplated that we should do differently. And over the years, we've been successful in persuading the commissioners that maybe we don't need to grant or deny all the street time in this case. So we're doing much better on that. The other thing I want to tell you about, it's a smart justice reform that I imposed, it's been about 2 years. We implemented a notice to appear process, and so we've heard so much about the civil citations for the juvenile sentence and even adult citations. This is very similar, but it's for those who have already been released and they're on supervision. If we find someone has committed a violation, it's willful and substantial, but yet it doesn't warrant a return, or we feel that, you know, if we put this person back, it really could cost them to lose their job or even lose their home. We've seen that time and again. Families are lost over these situations. So I have implemented a notice to appear process where we can just give the offender an opportunity to appear and address the violation, correct the behaviors without returning them to prison. We have done this in more than a handful of cases. It's been probably about 100, and we have already, with this one process, saved the state a couple of $100,000. So it's definitely a win-win situation for the state, it's a win-win for the communities, and it's a win-win for the offenders as long as there's no threat to the victim. We do this a lot on the technical violations, and there's also constantly, I hear it from coming downtown all the time, talk about technical violators, and so I want to spend just a couple of minutes and talk about those. Technicals absolutely are, missing a curfew by 5 minutes. Maybe someone is not paying the cost of supervision, or they're not showing up for the program treatment like they should. But a technical is also having contact with the victim when you've been told not to, when there's a stay-away order. A technical is also absconding supervision. It's also changing your residence or your employment, essentially making yourself unavailable for supervision. And again, we're talking about the most serious population of offenders. And so we do respond very seriously to technical violations. However, we do have the notice to appear process when it's warranted. And again, we're hoping that this will spread more. We've only done this on a few cases, as I said, but I do see this as a promising practice, and I can tell you that I've been sharing it with the Association of Paroling Authorities International as well, where I serve as vice president, and other states are starting to look at this as something that they can do with their population of offenders. We also had, I think it was around 400 warrants that were outstanding for absconders. And we partnered with the United States Marshal Service, and that was nationwide for them. We had 86 sheriffs involved and police departments, and we were able to close out well over 100 of those outstanding warrants. These individuals had gone out of country. They were hiding in plain sight in other locations, but we were able to close out some of those cases, and that was a very successful venture with the U.S. Marshals. And in fact, they want to have it ongoing all the time. They very much enjoy being a part of our process. We worked with the Department of Children and Families. We worked with the Department of Financial Services. Also in this project, they were all incredible partners. And if all that doesn't keep us busy enough, as I said earlier, the commission serves as the investigative and administrative arm for the Executive Board of Clemency. I can tell you, well, first of all, let me tell you what clemency is, in case you don't know. We read a lot about clemency, so I assume that we could quiz everyone in the room on it and you would have all the answers. But not only does it include restoration of civil rights, it includes restoration of alien status, it includes a pardon without firearm, remission of fines and forfeitures. It includes a commutation of sentence, and it also includes the capital cases, the death row cases. We stay very, very busy, and in fact, this comprises almost 50% of what we do at the commission. When I took over as chair in 2010, the backlog was 99,000 cases, a little bit over. Tremendous backlog. These investigations are not short in length, and they're not brief in information that they contain. These are exhaustive reviews of an individual's life, and we have to provide this information, and my team does an incredible job doing this. The rules were changed with the executive clemency process by this governor and cabinet, and every governor and cabinet does it. We just have to adjust to all the new changes every time it happens, and we do an incredible job doing that. Some of the cases, because of the rule changes, were not eligible. I can tell you today, and I am incredibly proud of this, while it's not a backlog that I would ever want to have, it is so much better. We have a night crew working, I have weekend teams working. We are busy about bringing down this number. Today, we have 10,884 pending restoration of civil rights cases. A little bit over 500 of those are the nonviolent offenders, the restoration of civil rights cases that do not require a hearing before the governor and the cabinet. And then a little over 10,000 of those are the restoration of civil rights that are violent offenders, and they do require a hearing before the governor and the cabinet. The governor and the cabinet hold quarterly clemency meetings, and we're there every time, giving them at least 80 cases on the docket when that's appropriate. There are times that we may give them 70, but most times it's 80. Under different governors, it could have been as much as 100, so it just varies on what's going on. I will tell you that as one of the state's smallest agencies, we have to be very strategic and creative in how we address our workload. And again, this represents about 50% of what we do. And again, I do have teams working on this constantly. This is the way I give them opportunities to make more money. I revert some of the salary dollars to OPS when I can't give them increases in pay. And I'll say, here's a project for you to work on. I want this number to be this number in 3 months. Let me see what you can do. And they have not failed me yet. It's incredible. That's how we've got to the number that we are. Another thing that we do on clemency that we love doing, and that's getting out into the communities across the state. And we have had the fortune to do this on numerous times with various state legislators when they're holding their voter awareness or town hall meetings, community education efforts. We go out with them, and we've been all over the state helping individuals determine whether or not their civil rights have been restored, whether or not they should try to vote. And of course, we say don't unless you have had your rights restored. But we have been able to assist state legislators within this process, and we've been doing this for years, and it's always a good thing to do. I can tell you that I have been working in criminal justice for over 30 years, and I have been involved with various fronts on this system, and I am of the very strong opinion that there's no greater place to learn the true impact of crime than at the Commission's weekly hearings. It is amazing hearing the inmates' family members and supporters talk about the loss of their family member being incarcerated for so many years, how this trickle-down effect has impacted other members of the family. They too are victims, and I realize that. One of the things I've tried to do, or I have done, is implement an inmate family coordinator to complement the victim services coordinator position that we have. So when the inmate family members and supporters come to the commission, they have a dedicated member of our team that is to assist them throughout the processes. They can also call this individual at any time to find out the status of the case or the best way to move through the process. Again, we provide these very same services for the victims. But because the commission is the best place to see the impact of crime years after a crime is committed, we've reached out to at-risk youth. And right now we're trying to get into the Leon County schools, but when we have traveled throughout the state in particular, and our latest community was Gulfport, we had DJJ bring some of the children that they had that are involved in one of their programs, and there were about 7 of them, and one in particular, there was not a person in the audience that felt that this kid was going to make it. I mean, he acted out, he was very resistant, very disruptive. But what we heard just the other day from the department is because of the conversations that he was privy to, because of the interaction he had with the commissions, we actually stopped hearing cases for a point, or at a point, to engage in a Q&A with these kids. And the questions that they asked were very moving. You know, 1 or 2 of them had a father that was in prison, or they had been abused. And again, this one guy, he acted like he wanted no part of it. But what we heard from him is that since that day, there has been a remarkable difference in his attitude. He's now wanting to help those that are involved in the DJJ program that he is in more than obstruct. And he's really wanting to succeed. And so for that kid alone, it's worth what we do. It absolutely is worth it. You had to have seen him to understand what I'm talking about. The other kids were also impacted. We survey them before they leave to find out if anything they heard was beneficial, if they think they'll change the way that they conduct themselves or change any of their habits, and they all respond that they will, that it's been hugely impacted. There was one particular family that came up. This one woman was talking about her dad, and she was 3 years old when he went to prison. And so one of the youth could really relate to that, again, because this individual's dad was in prison, and he already was 16 years of age and was struggling very much with an absent father. Another thing that we have done as a result of trying to reach the youth is we've created a crime prevention panel. I have 3 very successful parolees who were juveniles when they committed their crimes, and they're now middle-aged men. They are giving back to the communities. They are involved in reentry programs, transition house type efforts. And then I also have a victim who was sexually assaulted and left for dead. And she is a part of the panel, and it's beautiful to watch them interact with each other. It's like, 3 big brothers protecting their sister, and she is just as protective and supportive of them. And you would think that there might be some discomfort with all of them together, but it's amazing that the way that they have blended. We go to the Preventing Crime in the Black Community Conference, and we talk to a packed house of youth. The kids can't get enough of them. They want to know, why did you get involved in these behaviors? Were you involved in gangs? Did you do drugs? What was your family life like? If it was a good family, why did you do this? And these guys talk to them as though they are their siblings or their children, and they're like, I was really stupid. I had a great family. I don't know why I did what I did. I think it was more peer pressure than anything. And then they want to know, what did you do when you first got to prison? What was that like? What was your first night like? What did you do when you got out? What's the first thing you put in place so you wouldn't get involved in criminal behaviors again? And then they talk to our victim, and they want to know what that was like. And she is just as honest with them as she would be, talking to me about it. She tells them just how traumatic it was. She's even written a screenplay, and I try to have her involved with our activities as often as I can. She has become an advocate with the state attorney's office, a victim victim advocate, but she also is advocating on behalf of inmates because she is a strong supporter of restorative justice. She has forgiven her attacker. He is still in prison, and she does not want him out because she knows that before he raped her, he had raped 3 others. So she knows he's a clear danger to the community, but he no longer holds her back. She's able to move beyond the victimization and still make a change and impact others with everything that she has gone through. So this panel is a very valuable tool for the commission, and we are using it to help our youth avoid getting involved in the system. That's all I have to share with you. I have rushed through some things. I understand that y'all have been hearing presenters and panels all day, but I did want to share with you some information about the commission because we are an agency that little is known about, and part of it is because we do just sit over there, do our work, do it quietly, and we are successful at it. I do believe that it is because of our informed decisions that we make and the evidence-based practices that we utilize that Florida continues to enjoy the low crime rate. You don't hear anyone saying, and we thank the Parole Commission or the Commission on Offender Review for their decisions in these cases. It's always the law enforcement community making an arrest or not making an arrest. It's the prosecutors, but the commission is a key part of the public safety arena and the criminal justice processes in our state. If you have any questions, I'll be glad to entertain them. Thank you. Thank you.
Okay, we have a question over here.
Thank you. I just have a couple questions here. First of all, you started out by saying you have a 96% success rate. That's how many released inmates over what period of time?
That is our latest stat, and I believe that the last number was 28 that were released. We don't release a lot each year. Right now, the current population of parole-eligible inmates is 4,500, a little bit over 4,500. The thing about the parole process is it's been in place many, many years. A lot of the more low-level offenders have already been released under parole. What we have are murderers and sex offenders, the kidnapping cases. This is what we see. And I like the comment that was made earlier that even some of the worst of the worst can turn their lives around. We just have to find the right time for that to happen.
Okay, so that was 28 over what period of time?
That was a 2-year period.
28 releases
I've
over a
been at
2-year period of time. That's okay.
Well, no. We released 28 last year. I think the year before it was 26. We average between 25 and 30 parolees each year. Since I've been at the commission, we have not had lower than a 92% success rate.
Okay, thank you. Yeah, that is good. And just to stick with the numbers thing for a minute, you said you had 191 on the conditional medical release?
Correct.
191 released
Cases
over,
that came to our attention.
oh, and how many of those were released?
Let me get you the numbers because I do have those in my comments.
I'm just a numbers kind of guy.
I understand. I love research and data. Over a 7-year period, the commission has considered 191 inmates for conditional release, and almost half, 95, were granted, 79 were not. On average, each year, I think we're seeing whatever the number is, the consistent pattern is we usually grant about half of what we are given.
Okay. And last, is there a process whereby, speaking of restorative justice, whereby an inmate can reach out to a victim or the other way around? The victim can reach out to the inmate to effect some kind of reconciliation.
Okay, this was not a plant for those of you in the audience, but thank you so much for that question. Barney said up front that I am stepping down from the commission in March 31st. My term's up May 31st, but I've determined that I want March 31st to be my last date. One of the things that I have yet to be able to accomplish, we've done so much, and I am so incredibly pleased with what we've done. Even in my letter to the governor, I told him that I was leaving behind an incredible team, but I am leaving with a strong sense of satisfaction of what we have created over the last 6 years since I've been chair. But there is one area that I have not been successful. I put it in my budget this year. We had legislators trying to get it accomplished for us behind the scenes last year. It didn't happen, but I put it in the budget request, and although it wasn't approved as part of the governor's budget, I'm still hoping that there's an interest in having this seen. It's called the Victim Offender Dialogue. We've already trained 7 employees on how to facilitate dialogue between the victims and the offenders. The victim that I told you that is a part of our panel, she is hugely into this process, and we brought an out-of-state trainer. We have cases where the victims want to talk to the offenders, and it's, you know, our system of justice is designed to keep the two apart, and for good reasons. You know, for the most part, for good reasons. But there does come a point in time for some people that they are okay to have that conversation, and that is, why me? Is there something I could have done differently? I know when I was in the governor's office years ago and I was working on a death case, the victim's daughter reached out to me, and she wanted to talk to the death row inmate, and he wasn't interested, but what she wanted to know was, why did he pick my mama out of all those women in the bar that night? What was it about my mama? And then she wanted to know if her mom was afraid. And, you know, some of these questions, that it may not be healthy for the victim to get answers, but my point is there are individuals out there that want to have that conversation. We train our kids when they're very young. If you have a conflict, you talk it out, right? Our system of justice does not provide for this opportunity, and there are some people that want to communicate. We know that there are many offenders across our state that are very remorseful. They would love the opportunity to sit down and talk to their victim. The issue with this program is it is not designed to allow the inmate to initiate that conversation. It has to be initiated by the victim. We don't want any further harm to come to the victim. Once the victim lets us know, or a state attorney's office or anyone, because like I said, we've trained several people, but once the victim lets us know there's an interest, then we will help them communicate with the inmate to see if the inmate's willing. And then there is a process in place where it can take 6 months of prep work, both for the inmate, both for the victim, and getting them to come together for that very first meeting. And then there are follow-up meetings. So the appropriation that I put in, the request I put in, I think it's $77,000. Last year I was asking for a little bit over $100,000, but I brought it down because last year I was asking for 2 facilitators per case. This year I said, well, let's just go with 1. Maybe we can get it with this. But it is a program that I think its time has come. It's been talked about in the state for many, many, many years, and I tried to get it launched when I was at the governor's office, and it would just, you know, if it's the last thing I could do before I leave criminal justice issues, I would so love to have a victim offender project going on in our state. It's very necessary. That's a long answer to a very short question. I apologize.
But a great answer. And Tina, thank you for your dedication as a public servant for all the years.
Thank you.